Star. Good morning. The Court of Appeals is now in session.
Good morning, everybody, and welcome to the virtual Court of Appeals. We're happy to see everybody, even in this unusual format. I think that you're all familiar with how we're going to proceed, since you're all seasoned counsel who have appeared before us in this sort of format. We will stick with our usual time frames, but I will note that because we're sensitive to the idea that sometimes there are occasional technical glitches that we need to be a little bit more flexible. We will have each side have their half hour, and I would like to know how the appellees would like to divide their time.
Your Honor, we're not going to divide it at all. Bank of Utah's counsel is present. If something were to come up where the court had a specific question, he is available, but we're not going to split the time.
All right, thank you. That will certainly simplify things. Judge Orm.
Judge Appleby, did I hear you refer to each side having 30 minutes?
Well, the appellants and the appellees collectively, and so the appellees would divide their time if they want to divide their time.
The usual 15 minutes aside, though.
Oh, yes, I'm sorry.
Gotcha. Thanks.
This is retirement brain. So at any rate, we will proceed that way. And it appears that the appellant has reserved 5 minutes for rebuttal. So with that said, we will proceed in the matter of the Phillips Living Trust. Thank you.
Good morning, Your Honors. Adam Affleck, appearing for Peter Phillips. Your Honor, this appeal has to do with 3 orders of the district court: an order dismissing a minor as a party to the petition, an order dismissing Peter Phillips as a party to the petition, and an order denying Peter Phillips' motion to intervene. I thought just a quick review of the real important facts would be helpful for the court. John Phillips, in his late 90s, died. In 2015, he died with a trust. That trust will reference as the JEP Trust, John E. Phillips Trust. He divided his trust assets into 3 shares for his 3 sons, Peter, James, and John. It might sound familiar to some. Johnny was the oldest, James was the second, and Peter was the youngest, and each got a percentage share. Peter's share was 25%. Johnny was named the initial trustee after John's death, and there were no restrictions for distribution of Johnny's share to him. But James's share was to be distributed under the terms of a subtrust. And Johnny, who was the trustee of the JEP Trust, was also a trustee of James's subtrust. There were no restrictions initially in the trust relating to Peter's share and the distribution of his share to him, but an amendment made just prior to John's death changed that. His share was to be distributed, quote, in a manner identical to James, close quote. Peter challenged this amendment in court. He also challenged Johnny's appointment as trustee. This action was settled. And under the settlement, which included all parties to the trust, all beneficiaries of the trust, Peter withdrew his claims challenging that last amendment and agreed to Johnny's continuation as trustee for the JEP Trust. But there was an agreement to appoint Rachel Selby, who is Peter's daughter, as trustee of the Peter O. Phillips Trust. Also, shorthand that as the POP or POP Trust. Notwithstanding Rachel's appointment under this stipulation, which we'll call the JEP Trust stipulation, Peter reserved his claims relating to accounting of and the distribution of the assets of the JEP Trust.
Council, do we need to worry about any of the prior iterations of the trust? I know that there were several of them that included things like the plumbing supply company, but do we need to think about that at all?
Well, I think yes. I mean, the trust, to the extent it was amended, there are certain provisions that weren't amended and certain provisions that were. And so the earlier provisions of the trust still apply to the extent that they were not changed. So Johnny, who was the eldest brother, he died within a year or so after John's death. And Bank of Utah was appointed as the new trustee of the JEP Trust. And under Article C of the trust, upon the death of any child, the share held for his or her benefit, to the extent not appointed by the child, shall thereafter be held for the benefit of his issue upon the principle of representation. This is found at this language is found at page 79 of the record. It's part of the trust. So what this means is that Johnny's children became the takers or the beneficiaries of the trust after Johnny's death. So Bank of Utah, after Johnny's death and having been appointed as trustee, made an in-kind distribution of some farm property in Logan, which was probably the most valuable asset of the trust, to Johnny's probate estate instead of to Johnny's children. Peter believed that Bank of Utah acted in breach of the trust agreement, not only by making a distribution to Johnny's probate estate instead of Johnny's children, but by breaching procedures that Bank of Utah actually set up to ensure competitive bidding. Moreover, Bank of Utah granted certain valuable offset rights to Johnny's probate estate as if it were a beneficiary of the JEP Trust. So based on these beliefs, Peter sued to set aside the distribution as being unlawful and in breach of fiduciary duties. So the first order, or in Peter's petition, actually his amended petition I'll refer to, the first claim was a claim for declaratory relief for determination that Johnny's children, instead of Johnny's probate estate, were the beneficiaries of the trust. Now, in connection with that type of a lawsuit, all beneficiaries are necessary parties. And so Peter named Johnny's youngest son, CJ, as a respondent in that petition. CJ sought dismissal on grounds that he had actually waived his interest to receive a distribution from the JEP Trust in exchange for concessions from his half-siblings and Johnny's estranged wife relating to Johnny's probate estate. They signed a settlement agreement in California, and there was some horse trading that went on.
Mr. Affleck, could I ask you to, you're quickly running out of time, and could I ask you to address the issue how Rachel Selby as trustee of the POP Trust and Peter as the beneficiary, or, well, you're arguing he's a beneficiary of that trust, how their interests are not aligned? Didn't she continue this challenge against the distribution to the JCP estate?
Yes, and I think what you're talking about is the question of the denial of Peter's motion to intervene.
Mm-hmm.
And of course, that motion assumes that Peter did not have standing on his own right, which I think is the more important issue in this case. But to answer your question, their interests were not aligned because Peter and Rachel had a falling out. Peter actually sought to remove Rachel as trustee of his trust. That action was filed in January 2019. And at the time of this motion of intervention, there were actually motions for summary judgment pending for her removal. Also, Rachel's interests were divergent from Peter's in that she was not interested in prosecuting the claims that Peter had brought. In fact, she dismissed some, or effectively dismissed some, by filing an amended petition after she was joined as a party.
But doesn't that give him recourse against her later, independent of what's happening in these lawsuits?
It may, but even though it may give him recourse later, what it does show is that there is a divergent of interests, and Rachel's representation of him is not adequate.
So can I get you, yeah, you did answer my question. So then can I get you back to the standing question? And as far, it seemed like the district court pretty much followed the plain language of the statute in determining whether or not Peter was a beneficiary. Can you walk me through why he's not a trustee? It seems like your argument is he's not a trustee, therefore he is a beneficiary. Walk me through that argument.
Well, I think well, first of all, I think he is a beneficiary, even though there was a determination, or even though the POP trust took over the distribution aspect of what Peter's share, what was going to happen to Peter's share. He remained a beneficiary under the plain language of the statute for determining what a beneficiary was. The court, even though it wasn't argued by the parties specifically, the court determined that Peter was not a beneficiary under the terms of Utah Code Section 75-3-103B, which provides in part that a beneficiary includes someone with a power of appointment. And the trust document itself contains a power of appointment for Peter. Notwithstanding these provisions on distribution of the three brothers' shares, two of whom were to be distributed through the terms of a subtrust, they were given a power of appointment in case they died before the distribution from the JEP trust to the subtrust occurred. And that power of appointment provides Peter with standing as a statutory beneficiary. Of course, that argument was not made below. So it's not, I wouldn't say it's our strongest argument on appeal. However, the court did make a determination under 75-3-103 and under the Shakespeare case and other cases where a court makes a determination, that issue is deemed preserved for appeal, even if the parties didn't argue it below. But the real reason, or the real question, is whether Peter has a sufficient stake in the questions regarding the administration and distributions of assets from the JEP trust to have standing. And if you read the document, and this is where I think Judge Appleby's question comes in, what provisions of the trust document control? Those documents together indicate that Peter was to have a 25% share, and his 25% share is to be distributed through the POP trust. Trust does not indicate that Peter is disenfranchised from complaining or reviewing what happens to his 25% share. In other words, well, I would say that under the terms of the trust, Peter was not disenfranchised from questions regarding the accounting and distribution of assets of the JEP trust to the POP trust. And that actually was confirmed in the JEP trust stipulation, which, as I noted at paragraph 9 of that stipulation, provides that Peter's claims relating to the accounting and distribution of the assets of the JEP trust are preserved. So even though that stipulation appointed Rachel Selby as trustee, it also preserved Peter's claims relating to accounting and the distribution of assets of the JEP trust. And we would,
Thank you, Mr. Affleck, but we have run way over your time.
oh, thank you, Your Honor. Thank you.
It's fine. You were engaged in answering our questions, and so you will have your full remaining rebuttal time when you come back.
Thank you, Your Honor.
Thank you.
May it please the court. Can you hear me okay? Yesterday's argument, I was a little quiet.
I can hear you just fine, Mr. Boer. Thank you.
Thank you. Troy Boer on behalf of Sean Phillips, Michelle Biddleman, Charlene Phillips, and Doris Rubio. I'd like to direct the court's attention initially to the actual motion to intervene, and the substance of it does refer to the lawsuit by case number that Peter filed against Rachel. What he failed to mention was that lawsuit was dismissed with prejudice October 2nd of this year. And so there are no claims of adversity or any kind of breach of fiduciary duty or anything like that pending against Rachel. Second, I would note that the first thing the court needs to go through is whether Rule 4B, when it says a party timely files a post-trial motion and it tolls, whether that means that it must be filed by a party. And the court in Lamoureux versus Black Diamond Holdings, 2013, Utah Appellate 32 at note 5, notes that when a party is substituted out of a case, they are no longer a party. And when a party's motion to intervene is denied, they are not a party at that point, particularly after final judgment. And so you have to be a party to file a Rule 59 and 60 motion. Yes, Your Honor.
It appeared to me that Judge Christensen Forster had a question.
No, he answered my question. Thank you, Mr. Boer. I had a question about 4B, so.
Yeah, so I think that the first thing the court has to determine is whether it has jurisdiction at all, because no appeal was filed within 30 days of final judgment. It was filed after resolution of a post-trial motion, but a post-trial motion that is not filed by a party does not toll the time to appeal under Rule 4B, and therefore I don't think the court has jurisdiction. That's, unless the court has questions, I really don't have anything more to say about that. I think
does the fact that, I mean, you would argue, I guess, that because the court accepted the settlement and dismissed without addressing Mr. Phillips' motion to intervene, that implicitly that motion was denied.
Yeah, I don't see any way around that under merger doctrine. And, the Rachel actually, in her opposition to the motion to intervene, pointed that out to the district court, that, yeah, it merged right into the final judgment and he had 30 days to appeal from that. So that's absolutely correct. I would also point out that we keep talking about this as if it were a motion to dismiss that was granted. It was granted in part and not in part. But at 2790 of the record, which is the memorandum decision, the court clearly says the court finds it appropriate to substitute the trustee of the POP trust as the sole petitioner in this action. The petition was not dismissed, and then Rachel had to refile everything herself. She was substituted in, and the amended petition actually remained. And the court contemplates that right in the memorandum decision. So this is not a dismissal in the normal sense of the word. This is a substitution of one party for another, which shows that at that point, Peter is no longer a party to this action. I think it's important to characterize that the right way. The next thing I'll note is that Peter is definitely not a beneficiary to the JEP trust. That was litigated in the prior lawsuit that was referenced. It was the subject to a settlement agreement. The POP trust was put in place of Peter as the beneficiary, and Rachel was put in place as the trustee. And under trust law, the trustee is the entity that is the real party in interest to make claims on behalf of the trust, this being the POP trust. And the POP trust is the beneficiary of the JEP trust. And so there's no question that Rachel is the real party in interest and that there was no abuse of discretion in substituting Rachel for Peter in the lawsuit. And so there's, even if you reach the merits here, it's an abuse of discretion standard for substitution. There's no substitution here. Why is that? Because, Your Honor?
I was just going to ask you about the argument that he retained, even though the POP trust became the beneficiary of the JEP trust. So many initials here. Peter individually sort of retained the power of assignment or the power of distribution. His distributive shares, because they hadn't been distributed yet, he somehow retained that power. Which, am I totally confused?
No, you're not totally confused. The briefing is very confusing on this point. What happened is you have a petition that is challenging all kinds of things in the prior lawsuit. And the settlement agreement, like many settlement agreements, resolve certain claims and reserve others that are at issue. So what's at issue there are the distributions that are at issue in the prior lawsuit. Those are reserved. It couldn't have reserved a distribution including the sale of a farm that didn't occur until years later. And so it doesn't reserve that right. It in fact extinguishes the right to bring anything in the capacity as a beneficiary because he's no longer a beneficiary. So no, that document and that settlement has nothing to do with giving him standing later with a future distribution that couldn't have been reserved because it wasn't at issue in the lawsuit. And I'll just go through all of the alternatives that we've heard in the briefing and here today. One is that he has the power of appointment. And the argument in the reply is, well, the power of appointment, sure, it was only kicked in if I died before age 35 and now I'm over 70. So it's not really an operative provision, but age 35 is in the title, he says, and you don't read titles to be operative, but it's also in the text at page 395 of the record. And so that appointment was extinguished when he passed age 35. It has no role to play in this lawsuit at all. Next is this claim concerning plumbing property. Yeah, if you go to the original trust, that language is there, but the Third Amendment to the trust extinguishes it, replaces it, and says exactly what's going to happen with the plumbing property. That's at page 105 of the record. The CJ issue, that has to do with a different beneficiary to an heir to Johnny. It doesn't have anything to do with the POP trust. It's a substantive merits challenge, and therefore he has to have standing to even get to that issue. He has to prevail on standing before you can even get to the CJ issue. So it has really nothing to do with this lawsuit either, or this appeal, because you're not going to be able to reach it on appeal anyway, because you first have to reverse and give him standing. So none of these are alternative bases, Your Honor.
And did Rachel, Miss Selby, did she, CJ or his guardian ad litem did not file an appellee brief in this lawsuit. Do we need to even reach those issues?
No, you don't reach it for two reasons, because you don't have the right party here making it, and you have a party without standing who is making it to you in a case where you don't even have jurisdiction. So I'll point out that leaves him as making an argument that the substitution was an abuse of discretion because I satisfy one of the exceptions as a beneficiary of a subtrust to have standing to bring this claim on my own. And these tests are governed by the restatement, but they all basically go to either there is no trustee or you're adverse to the trustee. And we know that you're not adverse to the trustee at this point in time because, number one, you didn't allege it in your petition, which you have to give yourself standing. It has no such allegation. It just alleges that he is a beneficiary of the JAP trust. That's the only argument that's made there, or allegation. Number two, in his motion papers and in responding to Rachel's motion to be substituted in, he says, I don't have a problem with Rachel being substituted in. I just think she should be alongside me. That's not adversity. And so there's not even a claim that there's some kind of hostility here that would trigger the exception. So there is no abuse of discretion whatsoever. In fact, it would have been an abuse of discretion to deny the motion to substitute in Rachel as the real party in interest, as insofar as she's wearing the hat as a trustee. So that leaves the motion to intervene. The motion to intervene is untimely per se, because it was filed after an executed settlement agreement under the court's holding in Supernova. But it doesn't matter because it's untimely not per se. It's untimely on a reasonableness analysis under Questar. There has to be a reasonable explanation for the delay if you have notice of the proceedings. So what do we have here? 34, 31 through 32 of the record. On May 25th, 2019, Rachel sends a letter to all beneficiaries, including Peter, saying, hey, I think this is a reasonable settlement offer. Here's what I'm planning to do. If you have any input on Sean's offer of settlement, please contact me by May 29th, 2019. Yes, Your Honor.
Didn't she basically do that twice?
Yes. And then there's another one on September 25th, 2019, when the landscape had changed. Going forward, I think this is a good set. I'm going to try to negotiate something else, but if I can't do it, I think this is a good settlement offer. This is at 3434. Quote, the cost of litigation outweighs the potential benefits of continuing to fight the issue to the date of death value of the property. Please send me your comments or thoughts on the above, if any, by October 2nd, 2019. So no comments received. And the motion to intervene isn't until November 7th, 2019, after everyone has executed the agreement. So it's per se untimely, and it's untimely as to notice and sitting on your rights. It also does not have a pleading attached to it.
So how much weight should we put on that? I mean, I know it's a sort of technical failure to meet the rule, but isn't the substance of what would have been in that pleading contained in the motion?
Absolutely not, because, so number one, what I'll say is the rule has now been changed to say that the substantive basis can be in the motion. That was not true in 2019. So that
no, but we do have case law that says it's kind of silly to
but his
write all
argument
this
is,
paper.
his argument is that I referred to another pleading that's in the lawsuit. It can't possibly be the right one. Let's think about what's happened. You've got a challenge to the sale and distribution. Those are settled. It's subject to a settlement agreement that the parties have already executed. Your pleading can't be a challenge to the sale. Your pleading has to be a challenge to the settlement agreement. If you can't undo the settlement agreement, none of those claims are at issue because they've been settled. So you can't complain about the sale. You have to say that I have grounds to set aside this settlement agreement, and you need to provide everybody notice of exactly what it is you're going to do. I don't think it's an abuse of discretion for how the court interpreted the rule to require a pleading under those circumstances, which clearly sets forth, number one, when did you become adverse? When did Rachel not adequately represent your interests here? What precisely is it that you think that she's doing wrong? Instead, he refers them to a case number in a different lawsuit that he's filed against Rachel, which has now failed on the merits. So I don't think, even if it were timely, that it's adequate in any of those ways. And so the court certainly did not abuse its discretion in denying the motion to intervene, nor did it abuse its discretion in substituting Rachel as the real party in interest. And what that means is that Peter was not a party at the time that the final judgment was entered in this case. And that means that anything that he filed subsequent to that cannot operate under Rule 4B to toll the time to appeal. The court has no jurisdiction. Even if it does have jurisdiction, there's no abuse of discretion on either of those grounds. If the court doesn't have any questions, we'll submit there.
Thank you, Mr. Boer. It doesn't appear that there are questions. So we will hear from Mr. Affleck on rebuttal.
Thank you, Your Honor.
Mr. Affleck, before you launch into your rebuttal argument, and I recognize that this is mostly about procedure one way and another. Several potentially dispositive procedural and jurisdictional issues. But after all was said and done, when I'd read the briefs, I was, excuse me, I was left with the impression that your client was fussing mostly in the spirit of the principle of things. Certain things should have been done that weren't, and this provision was violated. This distributive scheme wasn't followed, and that's well and fine. But after all is said and done, can you tell me the essence of your client's injury? How has all of this harmed him? What does he see at this point? What is he out? And I apologize if I missed this in the briefing, but at this moment, I don't know what wrong exactly, what remedy, what measure of damages he believes he is due. Can you can you straighten me out on that point?
I think so. Bank of Utah, as trustee of the JEP Trust, determined to sell its most valuable asset, this farm property, through an in-kind distribution to someone that was not a beneficiary of the trust. In so doing, there were concessions on price issues, and the procedure for getting the highest and best offer for that property was not followed. Peter believes that if it had been followed, the value that could have been received by the trust was substantially higher, making his 25% share larger, which in turn would be distributed to him through the provisions of the POP Trust.
But hadn't they had
I
appraisals?
appreciate that. Oh, sorry, Judge Appleby, go ahead.
Well, it seemed to me from what I remember of the briefs that appraisals had been done, opportunities for offers and bids had been sought, and that the final selling price exceeded the highest bid. That mistaken?
I think it is mistaken. The problem is, Your Honor, is we never got to that question. I mean, we can argue what would have happened had the court allowed the case to be prosecuted by Peter, had those issues actually been tried, but they never were.
Right. And I apologize, Judge Orm, I interrupted you.
Well, with a follow-up question that I was going to ask myself, so thank you.
So just a few things on rebuttal. The appellees argue that the JEP Trust stipulation put the POP Trust in place of Peter for all purposes as a beneficiary, and that's just not true. The provision of the Third Amendment said that Peter's share would be distributed to him pursuant to the same terms as James, in the same manner in which James's share. The POP Trust is a distribution tool of Peter's share. It is not necessarily substituted in as the beneficiary of the JEP Trust. When you read the JEP Trust, it's all about Peter, James, and John. It is not about Peter, Peter's trust, James's trust, or Johnny. And James's trust, when the trust document was first signed, it was intended that his share be distributed to him through a trust, but the trust provisions still provided for James to have control over what happened to his share. For example, when we talk about the plumbing property, it was James who had the opportunity to determine what happened to his share relating to that plumbing property. Now, if James was not a beneficiary, why would James have any right to determine what would happen to his property? Also, this power of attorney, Mr. Brewer makes an argument relating to the fact that the testamentary power of appointment provision is under a major heading that talks about what happens if you die before you're 35 years old. But if you look at paragraph or Article 1C4E, that's the provision. It says nothing about being 35 or over 35 for that provision to take place. And basically, it is that if someone dies, if a beneficiary dies, and in a will he says, I appoint, this is how I want my interest in the JEP trust to go, that's how it goes. If it doesn't go that way, it goes to the kids. The further evidence of that intent is reflected in the JEP trust stipulation, where Peter is, even though Rachel is appointed as trustee of the POP trust, it is reserved for Peter on issues of accounting and distribution of the JEP trust assets. All parties reflected that intent in that stipulation, and it was that stipulation that was the primary driving focus of the district court's ruling, and we would submit that he just ignored the importance of that provision. On the question of CJ, it's argued that Peter is not a party, has no standing, has nothing to gain or lose. Well, he does. At the very least, the district court issued sanctions against him for $13,000 for failing to dismiss CJ as a party. And I would say that at the very least, that gives Peter standing on appeal to question the propriety of that ruling.
Mr. Affleck, I'm afraid that we're out of time.
Thank you, Your Honor.
So, and I don't think that the panel has any further questions. So I think we will conclude this session now. But we thank the council for their presentations today. This is in some respects, a factually kind of complicated case. And it has been helpful to hear from each of you, and we appreciate the efforts that you put into your presentations today. We will, as is our custom, take this under advisement and get you a written decision as soon as we can.
Thank you, Your
Thank you.
Honor.
Thank you,
This
Your Honor.
court is in recess until 10:30.